If you leased a defective vehicle in California, you might be protected by the state's Lemon Law, specifically designed for consumers like you. The California Lemon Law, also known as the Song-Beverly Consumer Warranty Act, covers leased vehicles that have been repeatedly repaired for the same or similar issue during the manufacturer warranty. So, what does this mean for you? If your leased car has recurring issues that affect its safety, value, or use, you might be eligible for a refund, replacement vehicle, or cash compensation. A Lemon Law refund is where the manufacturer repurchases the Lemon vehicle and refunds all monies spent on the vehicle, including your down payment and monthly payments. They will also reimburse any incidental expenses related to the Lemon, such as tow and rental car costs, as a result of the vehicle being a Lemon. The manufacturer will also pay off the remaining balance on the lease. With the replacement options, the defective vehicle would be replaced with a similar make and model. With both the refund and replacement options, the manufacturer is entitled to charge a usage fee, which is the value for when the vehicle was driven without problems. Alternatively, a cash settlement may be offered. This is where you would keep the vehicle through the lease end and receive cash compensation for having experienced a vehicle with issues. If you suspect your leased vehicle is a Lemon, or if you have any questions about a problematic vehicle you bought or leased in California, the Lemon Law experts can help. Our attorneys have recovered millions of dollars in compensation for consumers across the state since 2009. To learn more about the best options available for your case, contact our team at 877-885-5366 or visit us at nolemon.com today.